Good evening, everybody. This is Advocate Shraddha Dalvi. I welcome you all for our CPC continued lecture. I'll request Advocate Vaishali Tikle to give small introduction about Jaibhave, sir. Vaishali Tikle, please.
Good evening, sir. Thank you, Shraddha. Good evening to one and all connected for this webinar series. As we all know that yesterday part 1 of CPC has already been done. So now today we are going to continue with the second part of Civil Procedure Code. And again, I take the opportunity for those who could not get connected yesterday. I will introduce our speaker, who is a dynamic personality, also a multifaceted personality. Sir has 32 years of standing in this field, and in the field of civil, revenue, land acquisition, criminal arbitration, consumer, cyber laws, conveyancing, matrimonial laws, and banking laws. Sir has authored myriad books, namely Civil Pleadings, Conveyancing and Drafting, Cross-Examination, CPC, Approach to Trial, Hindu Succession Act, etc. Sir was a member of Maharashtra State Law Commission and also Bar Council of Maharashtra and Goa. He was a chairman in 2008, 2009, and vice chairman in 2008-9, and chairman in 2010 and 11. Sir has various achievements with him, but the noted one, amongst others, are he coined the idea of e-library at Nasik in 2005, which is commendable. And during his tenure as vice chairman, he established computer law libraries throughout state of Maharashtra and Goa at 425 places. So I know that, I'm sure that you are very keen to hear him, and without any further ado, I will hand over the microphone to sir. Sir, I welcome you.
Yes, okay. Thank you very much, and again, good evening to everybody. I hope that we have a more better, clear audio as well as a video today. Of course, the working has been done by the service providers very good, and we are thankful for them, particularly in this difficult time that they have provided us this platform. So coming to the second lecture today on a civil procedure code. Yesterday we have seen that how the composition of this document of the civil procedure code is done, how the sections, orders, appendix all are included in this particular document of CPC. Today we will pinpoint on some of the important topics which we repeatedly refer during our practice, particularly for conducting a civil trial. So most important one of that topic is of an amendment of the pleading. You all know 617, Order 6, Rule 17. Perhaps we don't know any other provision of the law which we can be said to be well acquainted other than this Order 6, Rule 17. We have to amend, we have to face the amendments. Many times the courts criticizes us when we talk about the speedy trial particularly. The court says that you come with an indirect adjournments, and one of the important tool for an indirect adjournment is an amendment application. We have to face that. But the reality of the life in a practice of an advocate is that he must be well versed with the provisions of the amendment of the pleading. So Order 6 particularly deals with the general comments on the aspects of the pleading. What is pleading, how the pleading should be there, how the nature of the drafting should be there, how the sequence should be there. In that entire process, it comes to Rule 16 and 17 of Order 6. So Order 6, Rule 16, we are not well acquainted, we don't use that Rule 16 frequently, but we use Rule 17 very frequently. Rule 16 deals with striking of the pleading, and Rule 17 deals with amendment of the pleading. So the word amendment, very important thing which the lawyer must know, how the words are important when an interpretation of laws are done, how the word is important, particularly this word amendment. We must just have a slight deviation, and I will just give an example of a very famous case which was relating to the amendment of the constitution, and there was a controversy. 13 judges were sitting together, and you know that famous case, I did not name it, Keshavananda Bharati. In this case, the important aspect was that whether the lawmakers have a power to amend the constitution. And before that, there was a Golaknath case, you know that. And therefore, the question was that whether the constitution should be amended. If amended, how it is to be amended. So, entire argument, first part of the Keshavananda Bharati, was revolving around the word amendment. So there was a 13 judges. 6 judges came to the conclusion that Parliament do not have any power to amend the constitution. It is absolutely prohibited. 6 judges come to a conclusion that yes, Parliament has all powers. They can do whatsoever they want with the constitution. 368 article is there. It is ultimately a document given to the people of this country by the Parliament itself. They are the makers and they can amend it. So 6 versus 6. 6 says no, 6 says yes. The 13th judge was Justice H.R. Khanna, one of the legendary name in the history of the legal history of this country. Justice H.R. Khanna delivered a judgment independently. And he said, friends, you are propagating so many things, right from the philosophy to the constitution, its principle, its preamble, everything you are dealing. You are arguing, we are hearing, you are also delivering in a judgment. What we are dealing today, he said that we are dealing the word amendment. The question is that for amending a constitution, what powers Parliament has? So ultimately, we are dealing with the word amendment. So let us discuss this word amendment. What is this amendment? And he said that when the constitution itself has Article 368, which says that constitution can be amended, it can be amended. What is wrong in amending a constitution? But he made a subsequent observations in the judgment. He said that what you are going to amend is important. And he says that a simple example of the suit you can consider. A suit is to be amended with a simple principle that the basic nature of the suit should not be changed. The subject matter should not be replaced, as if it should not look like a new suit. It should carry the original tone, the subject matter of that original suit. In that originality, you can distract something which is not consistent, but you can't change the entire suit. If you are going to change the entire suit, that is not an amendment, that is a replacement. And with this argument, he made a proposition of a basic structure of the constitution. That all law students knows that. Then he propagated that this will be a basic structure. We are not going into that details of a basic structure. The question is that the question of making an interpretation, whether it is a trial court, whether it is a high court, whether it is Supreme Court, whether 13 judges are sitting, 5 judges are sitting, or a single magistrate is sitting. The simple rule of interpretation is that the grammatical meaning of the word which you are dealing with will be a first and prime consideration. Try to find out that particular meaning. So the amendment means whatever is there in that, keeping its original nature as it is, making certain changes. That is amendment. And therefore, the Keshavananda Bharati has then led on this principle of maintaining the basic structure of the constitution, entire law. And friends, therefore, not only for an amendment, as a student of law, we should go on reading repeatedly, at least Keshavananda Bharati 1 and another case, that is ADM Jabalpur versus the Union of India. Because there also the question was well raised that what is the nature of a fundamental right, whether it is a gift given by the constitution or it is an inherent quality of the human being on the basis of which the fundamental rights are given. These two, and we must always remember Justice H.R. Khanna, who has given a very sound basis to make an interpretation of a law, right from this word amendment up to the fundamental right, which he again had a minority judgment in an ADM Jabalpur versus of Union of India, in which he said that it's not a gift given by the constitution, but it's an inherent quality of the human being. Because of that, fundamental rights are there. You must be knowing all the young generation. You can go to the YouTube and you see that in that particular time when there was an emergency in a country, there was no publication of this decision, which was given in an ADM Jabalpur by Justice H.R. Khanna. But New York Times at that particular moment has written an editorial. In that editorial, they respected H.R. Khanna and they said that Justice H.R. Khanna, whenever there will be a monument of the democracy in the country of India, the topmost rank in that monument will be to Justice H.R. Khanna. So these all great judges has given a different scope of the interpretation. And therefore, when we consider amendment in a suit, the simple ratio which is referred in an Keshavananda Bharati, we need not change the suit. That we all know. We did not talk much about that. And therefore, making an amendment is a right if it is consequential to your own pleading. It is helping for an adjudication which is original subject matter of your suit, and it is not something new case which is deviating from your original case. If it is supplementary to that, if it is deleting something unwanted, it's all right. But it should not be parallelly a new case whereby making an amendment will bring you on a different footing as a plaintiff. That will create a disadvantage to the defendant. So, defendant can always object. He can object that it is creation of a new suit. It is a creation of a new case. He can object that it is out of limitation. He can say that this is not a bona fide. He can say that this is for the causing of a delay. He can say that it's scandalous, is fictitious. He can make so many objections, and he can, of course, oppose that particular amendment. The question is that when such particular amendment comes, every advocate should always have his own noting, in which cases the amendment will be allowed and in which cases amendment will not be allowed. Which are the provisions? Which are the basic case laws up to the recent development of the law on this particular aspect? It's only Order 6, Rule 17, with an additional factor of Order 16. It has a reference of the civil manual. Here, I will request all my brothers and sisters in the profession, particularly while doing a trial court work. A civil manual is an equally important document which is always with an impression of a bar also and a bench also, that it is a document only for the judges and the official minister work of the office. It is not that. It's a supplementary thing to the Civil Procedure Code. or even for the criminal procedure code, or for any other litigation. If you can go to the land acquisition matters also, you will find that there is a different manual. If you go to the Watan area, Watan laws, Inams and Watan laws also, you will find that there is a different manual. This manuals is nothing less than a detailed procedures. As far as the amendment is concerned, section 151 is the only reference section here. Order 6, Rule 17, 16 and 17 is a referable provision here. Also, you can go to the manual and you will find that in para number 79 to 81 of the civil manual, para number 79 to 81, you will find the detailed directions, instructions for carry out, for conducting the applications of amendment, for opposing the applications of amendment, and also for carry out the amended part of the pleadings when it is allowed. So this aspect, importance of the amendment is of an immense importance in the practice of the advocate. If an amendment, either it is rejected or allowed, what is the remedy? It's not an appealable thing. Neither it touches to the finality. So there is no revision available. So only the remedy available is that you can go in a writ jurisdiction where you can show that how the judge has exceeded its jurisdiction, how the judge was not proper in following the natural principle of justice or any other reasonableness of that particular order, how it was required, that amendment, how it was necessary. And in that particular aspect, you get remedy to writ petition when either it is rejected or when it is allowed and when you have to go further. Of course, whenever these objections of amendments are either way are not considered by the lower court, in an appeal, you can take a specific ground when you are referring an appeal, though you have not challenged it before the higher authority by filing a writ petition, you are open to take this ground in an appeal. And there you can argue that how my amendment was correct, how that amendment was wrong, and how the lower court has not appropriately considered the aspects of legality of this particular amendment application. It will be considered by the lower court, and even at that particular junction of hearing an appeal, you can make this type of an amendment. Making an amendment in an appeal is a different question, so I will not touch because we have decided to restrict ourselves to the trial aspect, the suit from filing of the suit up to the judgment and decree of the aspect, and related provisions of the Civil Procedure Code to have a concentrated discussion on one particular aspect of the CPC. So friends, amendment is important. Now here I want to impress you on another thing. Apart from Order 6, Rule 17, when you are dealing with a particular type of a litigation, it may happen that for your own amendment, you will get a support from some different statute itself. For example, let us consider the suit for a specific performance. Here, you have made a specific performance. In that particular specific performance, alternatively, compensation can be claimed. You have made a declaration suit, you have not made a possession, or you have made a relief of possession and you are not asked for the declaration. Like that. In a suit for a specific performance controlled by the Specific Relief Act, if this types of situation comes, suppose the first example of a compensation, and if you want to make that relief now in a suit of a compensation, you will file an application for amendment because you know under section 21 it is said that compensation can be given, but compensation cannot be given unless it is claimed in the suit. So you come to knowledge that this type of a provision is there. I am not claim a compensation. So naturally, the another advice will be there, or your mind will think of that let us go for the amendment. Or if the suit of a possession is there, some declaration is not asked, it is in your mind that no, I should ask this declaration also to have a complete adjudication of the matter. Now this situation come before you. So which provision for an amendment of your pleading you're going to avail? That is the question. Here, Order 6, Rule 70 is the only solution for you. Order 6, Rule 17 is up to the discretion of the court. But if you see the provision of Section 21 and also Section 22 of the Specific Relief Act, you will find that the provision is there. In that provision of Section 21 itself, the statute says that if the compensation is not claimed by you, you will be allowed to amend the suit. I will refer this provision because many times I have found that many times we just forgot to refer to Section 21, 22 when we make an amendment, particularly in such circumstances of the suit for the specific performance. If you are referring to Section 21 or 22, rather than only going to Order 6, Rule 17 for making an amendment of the suit, I personally feel that you come on a very perfect statutory footing and your amendment is bound to be allowed. No discretion, no question of discretion is there because the provision says so. Section 21 deals with the power to award a compensation in certain cases. In a suit for a specific performance of a contract, the plaintiff may also claim compensation for its breach, either in addition to or in substitution of such performance. Then all criteria is given, subclause 2, 3, 4, 5. In a 5, subclause 5, it is there that no compensation shall be awarded under this section unless the plaintiff has claimed such compensation in his plaint. Now here the next proviso is important. Provision says that provided that where the plaintiff has not claimed any such compensation in the plaint, the court shall at any stage of proceeding, allow him to amend the plaint on such terms as may be just for including a claim of such compensation. So Section 21 comes to your help. If you want to make this amendment, then it is not only Order 6, Rule 17, but it is Section 21, which is specific, mandatory, and that gives you a right, a mandate from the court that I want to make this amendment, and this amendment should be allowed because it is permissible under Section 21 of the Specific Relief Act. Same is the case of Section 22 also. Power to grant relief for a possession, partition, refund of earnest money, etc., notwithstanding anything to the contrary contained in the Code of Civil Procedure Code, anything. You just consider, friends, this terminology, notwithstanding anything contained in the CPC, whatever may be there in the CPC. In spite of that, if in a suit of possession, partition, refund of earnest money, any person suing for a specific performance of the contract for transfer of immovable property may, in an appropriate case, ask for possession, partition, etc., etc., no relief should be granted unless it has been specifically claimed. And then again, the same proviso reflects here, provided that where the plaintiff has not claimed any such relief in a plaint, the court shall, at any stage of the proceeding, allow him to amend the plaint on such terms as may be just for including a claim for such relief. So the question is that Order 6, Rule 17 is there. Apart from that, in such time, at least in a Specific Relief Act, as per my own knowledge and my own observations, we had another support of the provision of a law, Section 21, 22. We must go to that provision then. Then we should not rely only on an Order 16, Rule 17, because Order 16, 17, the section itself says that notwithstanding anything contained in that CPC, you have this particular right. So your application should be only under Section 21 or Section 22 for making an amendment of your suit in such types of cases. I have not come across any other statute at present. As on today, I'm making a research and I'm preparing for that also, that how the amendment aspect with dealing to the another different types of topics can be dealt with by taking the help of the statutory provisions of the law. As far as the specific relief act is concerned, this 21 and 22 gives you a different stand, a very sound stand when you are making an amendment, and that makes your relief of an amendment strong one. So now the question is another aspect of striking off. Striking off is not an amendment, first of all. It can be with an application. It can be without application also. In fact, it is a discretion, power, authority given to the court themselves. Some unnecessary, some scandalous, some fictitious, some non-bona fide things, unwanted thing, hampering the fair trial, causing delay, if such types of pleading are there. And it's important, friends, nowadays we find that the suit comes with a 50 pages. When the forefathers of this profession has taught us that our pleading must be precise and perfect. It's not a question of the writ petition. Writ petition is not a disputes or else a litigation relating to the facts. But civil suits or other matters where adjudication by proof is required, in that particular aspect, your pleading is the base. It should be small, it should be perfect, because for every word you are under obligation to give an evidence. So as far your pleading should be short, perfect, should not be less also, but with a minimum word without repetition. But if you are making a repetition after repetition, you are making some scandalous allegations, you are making some fraudulent stories, you are making some hypothetical contentions there. These types of pleadings, at least nowadays, will not have a place in a litigation forum, because, in fact, we want to give a speed now. Speedy trial is a fundamental right guaranteed under the Constitution. It is not only a direction, it's a fundamental right. So if an opposite party is making a scandalous pleadings, making a huge pleadings, 50 pages, 60 pages, 100 pages, repetition, which is not concerned with a real controversy in a dispute, then you have a right to make an application or to make an argument to the court that this particular all unwanted thing should be struck out. They should be removed. And that order is, of course, can be given by the court. Court can so to strike out, or court can say that you make an application, I will pass an order. So application, objection, and order will give you a relief. So this will be on a different footing. So amendment and a striking of the amendments are two different aspects which are important in the practice. In this entire procedure, my request will be that while concluding this particular topic, also refer to the civil manual from para 79 to 81 and see how small things are given consideration in a civil manual for every aspect. It may be appointment of the commissioner and completing the work of the commissioner. It may be amendment. It may be exhibiting a document for the purpose of proof. There's always good guidance, good help under the civil manual. So CPC and a civil manual, it should be read together, it should be understood together. And as yesterday I have told you, there is a one logical sequence based on the natural principle of justice. Similarly, in a civil manual also, that particular logical sequence of the natural justice is maintained with small, minute directions. If you go to the other states, particularly in the south, you will find that apart from the civil manual which we have, their manuals are there, but apart from that, they also have the court's orders, or they are called as the office notes, whereby certain directions are given in these types of procedures. And nowadays, when we want a speedy trial, when our trials are taking an age of 15 years, 20 years, friends, it's our duty as an advocate and also as a judge to see that this long age should be reduced, because ultimately it's not a question of getting a degree. It's a question of completing an entire litigation from a decree to a first, second appeal, and again coming to an executing court and giving an execution of that particular decree to the litigants. Unless we do that, we are failure on this aspect. In my last practice of 33 years, I am sorry to say that I was not able to execute 5 to 10 odd decrees in my entire life of the profession, because the long process of completing that decree and bringing it to the execution has to be curtailed. Otherwise, the people have already started going to other forums, and they will not remain with the trial courts. They will adopt some unauthorized forums, which will be not only the defeat of the civil trial, but it will be a defeat of the entire democratic process for us. So here, amendment is to be very carefully used. It should not be used as an instrument either of delay, adjournment, bargaining, nothing. It should be purely used for the purpose of the correction of the litigation, and that is most important thing in the practice of the advocate. That gives you a good impression before the courts also, friends. Otherwise, if unwanted applications of the amendments are submitted to the court takes it nowadays very strongly as a prejudice against you, because they feel that this person wants to misuse the process of the law and not he has to use the process of the law. So with this, friends, this first aspect of amendment is a very important. And also, I will request again that just refer to Keshavananda Bharti also whenever you will get a time, because it's 850 page judgment. Also see ADM Jabalpur, because the ratio, minority ratio of HR Khanna, that fundamental rights are not the gift given by the constitution, but a fundamental right is an inherent right of a human being as a human being, has been upheld by Justice Dhananjay Chandrachud sir, and it's very, very interesting, and also becoming making us proud to feel that the first judgment, the majority view, was Justice Y.R. Chandrachud, father of Dr. Chandrachud, and the son has reversed the judgment of the father and has adopted the judgment of a minority view given by Justice H.R. Khanna. So, friends, now coming to another topic. Yesterday I told that pleading is the best, plain and written statement. And the hearing starts from order 18 onwards, the evidence and then judgment. In between, there is order 10, order 11, order 12, order 13 before issues are framed. And we have to concentrate this part. What is this? These particular things are termed as, if we say the order 10, it is admission and denials of the facts. If it is order 11, it's a discovery. If it is order 12, it's an admission. If it is order 13, it's a document, presentation of or filing of the documents. If these orders are effectively used, the length of evidence is reduced and the quality of the evidence is better. You get a good quality of the evidence. For example, order 10 I have explained yesterday, but just for the reference, I will tell you that order 10 is not used in a practice. In a criminal matters, after filing of a charge sheet, once the matter is committed to the sessions court, the first stage before charge in a session trial is admission of a document in a charge sheet. That admission denial is first taken, and subsequent to that, then the matter goes on with the charge and all the other contest of the session trial. Similar to that, order 10 operates. It says that whatever facts are not admitted are disputed facts. Admitted facts are to be separated. All these facts, admitted facts, which facts, disputed facts, which facts, are to be recorded, and then the further proceeding should start. This is firstly on the basis of the pleading, plain and written statement. Then secondly, it's inquiry to be conducted by the judge, and rule 1 And another rule 2, 3, 4 gives ample power to the court to make such inquiry. From whom this inquiry is to be made, judge, after pleading, will ask to the lawyer, what is your exactly case? What controversy you want to make and adjudicate before me? The advocate should address to the court that this is a focus point of our controversy. The court can ask to the parties exactly what dispute you have and what adjudication you want from this court. The judge can call any person other than party as a witness. An important part is that this will be on the inquiry by the judge himself. He will ask the questions to the witness. It will be recorded in their evidence, but there will not be a cross-examination at this particular moment of this particular judge or the witness. The judge can call for a document which are not before the court, which are either in the custody of either of the parties, or even if they are in the custody of, in a possession of some third party. So all these exercise can be done by the judge, and ultimately judge will record which facts are admitted, which facts are denied. In today's situation, my appeal, I'm making appeal in all trial courts, in all seminars, and also I'm requestfully making appeal to you. Try to use Order 10 everywhere. I got a call from many places of Maharashtra that judges are telling, "Kai he navinच काढलं तुम्ही? Why you are making these types of applications?" It's again delaying the process. They feel that you are delaying the process. We should argue before the judge. This is not for delaying the matter. This is for curtailing the further process of a lengthy process of an evidence. Because many times, even on the admitted facts, issues are framed. Evidence is laid. It is not necessary. And therefore, you should give an application in a civil trial after the written statement is received, whether you are plaintiff or a defendant, that the admitted and the disputed facts should be recorded by the honorable judge in this particular matter. Then go further. So this is important. Here now, the most popular part of the current civil litigation again comes in Order 10, and that is the ADR, an alternate dispute resolution mechanism. We have mainly in our mind Section 89. Section 89 of the CPC. If it is found that there is an element exists in the litigation where element of compromise can be exhausted, then the judge should refer the matter for ADR. Arbitration, conciliation, mediation, lok adalat, judicial settlement. 5 types of ADR mechanisms are used. Order 10, Rule 1A, capital A, Rule B, and Rule C are 3 rules where it is said that after receipt of the written statement, it is the most appropriate stage for exhausting the possibility of ADR. So once a written statement is received, you go to Order 10, Rule 1 ABC. There all these mechanisms is there. And of course, friends, in a civil trial, it has become of utmost importance to give a proper consideration to all this ADR mechanism with understanding of the spirit behind that. The law which governs this ADR mechanism. We need not wait up to the 89. At some stage, after 5 years, 6 years, when no recourses are there, sometimes ADR recourse is tried. It's not a correct mechanism. It's not a correct procedure also. It is a procedure as per the CPC, amended CPC from 2002, that we must give a consideration for an ADR mechanism under Order 10, and the appropriate stage under Order 10 is that after receipt of the written statement, the next stage. And therefore, in Order 10, it is said to be the first hearing. First hearing where the suit may be admitted, and if the court found that it is admitted, there will be a judgment under Order 12 on the admissions, basis of an admission. So it's a first hearing, said to be a first hearing of the suit. It may be a effective a ADR. It may be effective, some sort of a compromise between the parties, and it is possible that the matter will be disposed of immediately after receipt of the written statement. Next date. The next date is the first hearing, where two opportunities are there: admitted and disputed facts to be segregated, recorded, and another, the mechanism of the ADR should be exhausted. Here, friends, what is the law behind all this mechanism of ADR should be studied. That is my humble request, because whenever the discussions goes on, whenever the questions are asked that what laws control all this mechanism, many times it is found that we are not perfectly sure which law governs. If it is an arbitration and a conciliation, friends, it is an Arbitration Act of 1996 and rules thereunder which control these two types of ADR mechanism. If it is a Lok Adalat, the Legal Services Authority Act and its entire rules, regulations, they control that Lok Adalat ADR mechanism. Now remains the mediation. Mediation, there is no separate law. But you will find that in a civil procedure code itself, there are mediation rules prepared. And every code, there is now Center of a District Legal Services Authority, Taluka Legal Services Authority. In this Legal Services Authority, you will find a manual prepared by the Legal Services Authority, where you will find more detailed rules, regulation, as a civil manual is there. Pre-litigation, what are the rules of the pre-litigation? Mediation, how mediations are to be conducted. Who is to be mediator? What should be the fees? How the parties are to appear? In what time it should be completed? And nowadays, everyone must know all these mechanisms, friends. Therefore, mediation is controlled and regulated by the rules framed under the CPC. The judicial settlement is the settlement which can be dealt with ordered by Order 23 of the Civil Procedure Code, a compromise between the parties before the court, and accordingly the compromise will be recorded as per Order 23. Here, what will be the difference between arbitration? You know, it's practically adjudication. But confusion comes when the question of conciliation and mediation comes. What is exactly the difference? Conciliator also sits and talks with the parties. Mediator also sits and talks with the party. Lok Adalat, there is a panel. As far as conciliators and mediators are concerned, they are individually, singly dealing with the parties. So what is the difference there? So one must understand the basic difference between these two concepts. Mediator is a neutral person. Conciliator is not a neutral person. Parties come, role of a mediator is there. He should give a patient hearing. Plaintiff comes, okay, what is your contentions? What is your complaint? Okay, you go. Defendant comes, okay, you go. Communicate that to each other. Whatever the reaction, actions, forces, disputes, let it be there. Try to bring the dispute out. Realize what is the real dispute between them. Because we know the disputes are different. The woman wants a divorce. But we can't write a divorce. We did not advocate rights a divorce. In the interest of that litigant itself, we write something else, domestic violence, or we write for some restitution of a conjugal right, like that. So disputes are different. The litigations are different. So mediator has to understand this. But mediator don't have to give us suggestions. You do this, you do that. That is not a role of a mediator. Let that suggestion should come from the party themselves. There, once the suggestions are there, formulation can be done by the mediator. But that is not a case of a conciliator. He is an active participant of an entire dispute. He can say, yes, what is your case? He can say, yes, what is your case? Why you are not doing this? You do like that. He can make suggestions. So conciliator has a different role. He is involved in an entire dispute. He is not a neutral person. He can just give his own suggestions, try to find out this solution, that solution, this solution, whereas the mediator is a neutral person. So difference between two concepts is that mediator is neutral, conciliator is not neutral. Conciliator can give us suggestions. Mediator can't give a suggestion. He should not give us suggestions. It should come through party. And the object behind this is that the real mind should be open before the mediator. The real intentions of the party should be clarified. They should not speak in the mouth of the conciliator, like conciliator from mediator also. Because many times the litigants come, they tell their story and they talk through the mouths of the advocates. Or then the dispute talks speaking through the mouths of the judges. It's not the mouth and mind all the time of the litigants. So the concept of the mediation is that it should be a real mind, mouth, and intention of the party concerned. And one should not get involved. That for the mediator is the neutral person. So this concept of ADR contemplated in order 10.1a is also, friends, an important thing. Now coming to the another part of the discoveries. Order 11 also and order 12 also, together we can see basically three types of discoveries are contemplated in order 11. First is interrogatories. Another is an inspection of document. And then there is notice to produce document. Three types of the different type of discoveries are contemplated. So let us focus first upon the interrogatories. What is interrogatories? Interrogatories is a written cross-examination on facts. It should not be of a law. The question should not be related to the law. They should be strictly on facts. First principle. The question will be designed by the parties. Question 1, question 2, question 3, question 4. Right from rule 1 to rule 11 of order 11 is for your guidance. You see that all rules. And very logically the sequence is given. You make an application, ask for the leave to serve interrogatories on an opposite party. It is available to both the parties. And then the court will consider your questions, consider your leave. Court will give you permission to leave to serve all questions. Or the court may delete some of the questions. Or court may delete entirely your claim of serving an interrogatory, depending upon the need of an investigation. And the purpose or the core focus of the court will be whether by making all these interrogatories, not seen facts, the facts which are not before the court, will be brought before the court. If yes, the interrogatories will be allowed. And therefore, for that particular purpose, importance of interrogatory is much. We should try to utilize this facility. In fact, these are instruments in the hands of the lawyer. The client doesn't know. Clients can give you an inputs. If you are talking about suppose a case of a specific performance where a party purchasing who has also created a default in another 2-3 cases, party has that information. You can put into the question whether you have also transacted with such and such person in such and such matter, whether you have also made a breach of that particular contract, like that. 1, 2, 3, 4, or whatever you're on a factual, you have to design your own questions and you have to ask this, which are relevant to the subject matter, so as they will be helpful for the factual assessment of the court, and accordingly you will be allowed. One set of interrogatory in one case is permissible, unless court otherwise think that another set can be given. But in a one matter, normally the court can give you the one set of the interrogatories. The interrogatories and the answer given in an interrogatory is an evidence, friends. It is an evidence. On the basis of that, you can deal with your evidence. In a cross-examination of a witness, it's a statement before the court, and on the basis of that, by using the provisions of section 44, 45 of the Evidence Act, you can make an appropriate cross-examinations also. You can develop your case once these particular types of interrogatories are there. After getting an information from an interrogatories, you can appropriately amend your suit also. You'll find the case law on this particular aspect that yes, you can develop your case. So this instrument of an interrogatory is very important. At least in some rural part, I'm told that in the original side of Bombay High Court, it's repeatedly and very usefully this instrument of an interrogatory is used for conducting a trial. But as a lawyer, trial lawyer, I have seen that otherwise the use is not that much frequent and that much effective. In fact, it is a very effective instrument in the hands of the lawyer of the litigant. The another aspect of inspection of a document, particularly when documents are referred in a pleading and they are not produced before the court, it's absolutely right available to the party to give such types of a notice. And I must tell, yesterday I was talking about the appendix of the CPC. Here, all the formats are given in appendix C. For interrogatories, you will find that form number 4 is there. If you go for the inspection of the document, you will find that form number 7 is there. To go for the notice to produce document, which is there in rule 14 and 14 to 16 of order 11, you will find that form number 12 is there. If you go for the notice to admit facts, document, etc., you will find that form is given there. You will find that civil manual helps you at many occasions. From para 84 onwards, you will find that various detailed procedures for dealing with these interrogatories, inspection of document is there. So inspection of a document, you can give a notice to court that these documents are referred in your pleading. You are not produce it, give me an inspection. Or otherwise also the document which are not referred in the pleading, you can mention there, they are relevant document, give me inspection of this document. The court will allow that particular inspection. As far as the documents which are referred in a pleading is concerned, you will definitely get a relief and court will allow you to make this inspection. This inspection need not be in a court. It can be in a office of the lawyer. You can give, if you are a plaintiff, to a defendant, if you are giving a notice in a office of the defendant lawyer, you can get an inspection of this document. Once inspection is completed, you can take a verified copies of that particular documents. And these verified documents can be used in an evidence, friends. So inspection, if this way you are making, it's very important. Court can pass order in support or consequential to this entire procedure, which is given in order 21, rule 7, 14, 15, 16, something onwards. All this detailed procedure for inspection of a document is there. We must use this instrument also. Notice to produce. Again, inspection is one remedy. But you don't want an inspection. You want directly the document to be produced by another party. One, referred to this pleading or not referred to this pleading by party. Order 11, rule 16 will operate. And you can take the form number 12 of the appendix C. In that particular form, you should give a notice to produce. If it is from some third party, then you can give your logical explanation. And also by using same format, you can also, under the provisions of rule 14, rule 16, you can make the application to the court for claiming a notice to produce that particular document. You must read this provision of order 11, rule 14 and 16 with section 66 of the Evidence Act. If a notice to produce is given and the other party is not producing that particular document, you are easily entitled to lead a secondary evidence. And you can simply make out the case that we want the original, it was not in my custody, it was custody of another party. I have given a notice to produce, he has not given a production, adverse effect is to be drawn against him. Apart from that, I had this Xerox copy, I had this XYZ copy, and kindly permit me to give this secondary evidence in this particular matter. You will be allowed. That is the scope of section 66. And where it is said that already the notice to produce is already given, it becomes right to go for a secondary evidence in that particular aspect. So, friends, this particular format of notice to produce is important. Last one, we are, I think, running short. Some 6 is there. That is notice to admit. Under order 12, rule 1, this can be given. Notice to admit of for what? Entire case. Notice admit my entire case. Next, notice to admit a particular fact. Notice to admit a particular document. 3 things are there in order 12, rule 1. By using all these things, you can give notice to admit also. So friends, in totality, I think these 4 instruments are most useful as per my own practice experience, as per my conception, and therefore interrogatory should be used, inspection of a document should be used, notice to produce instrument should be used, notice to admit must be given at appropriate time. After the receipt of the written statement, both the advocate must be very diligent. They should use order 10, they should use order 11, 12, 13. Even a production of a document is order 13, which is well acquainted to all of you, and therefore not taking you much time. So now the question, lastly, I will refer, because already 5 is there, and it was said that we can have some 10-15 minutes for a discussion. I don't know whether we'll get a time or not. But High Court amendments to the CPC should be understood properly, friends. I'll give a fast 3-4 example. Order 6, Rule 17. Amendment I was talking about. In Order 6, Rule 17, particularly in Rule 17, after 2002 amended CPC, one provision is there. Suppose in a suit, defendant is ex parte, and plaintiff wants to make an amendment in that particular suit. Then, as per Order 17 or Rule 17, in a Central CPC Act, notice need not be given again to an ex parte defendant. In Rule 17, Bombay High Court amendment is there. For Rule 17, I'm talking of Order 6, Rule 17. This is prior to 2002. It is of 1976. This amendment of a Bombay High Court is there, where it is said that if the defendant is ex parte and if plaintiff wants to make an amendment, then in that particular case, fresh notice should be given to the defendant. So now the question is that Bombay High Court amendment says that notice is to be given to an ex parte defendant also. If you want to make an amendment application should be served upon him. The Central Act does not say so. The question is that which is to be followed now. Basically, when 2002 amendment came, there is section 16 in that amending act. 2002 CPC amending act is an independent instrument. In that instrument, there are section 1 to 30, whatever may be the sections. In that particular section, the amending act, there is section 16. And that section 16 says that if henceforth any state amendment or High Court amendment is inconsistent to the original Civil Procedure Code, then the state or High Court amendment will stand repeal. This is the provision. The matter on Order 6, Rule 17 went to the High Court on this particular ground that Bombay High Court is inconsistent to the Central CPC. And Justice Wazirdar's judgment you will find in a Maharashtra Law Journal in 2011, where Justice Wazirdar, Bombay High Court has said that Order 17 does not stand. It is repeal now. Repeal means it has not taken birth at all. It is not in existence at all. So this aspect of a Bombay High Court amendment should be kept in mind. But they are important. How important? 2-3 examples. You see the caveat. And caveat, the meaning of the caveat is that if a caveat is filed, there cannot be an ad interim ex parte order. But if you have a case where very, very urgent matter is there, but the opponent has filed a caveat and you want an ad interim injunction, what you will do? You will find the provision in Order 40A of a Bombay High Court where caveat rules are framed. They are not there in a civil procedure code or in a central act. The 40A is only there in a Bombay High Court amendment. And in that amendment, there are 7 rules framed by the Bombay High Court as a caveat rules. In that caveat rules, you will find one rule, rule number 7, which says that in spite of caveat filed, if it is found that there is an urgent necessary ad interim injunction can be given by the judge. If you know this High Court amendment, friends, then only you can convince the judge that my urgency can be tenable before you. You can consider in spite of caveat and give me an ad interim injunction. If you can't, if you don't know this High Court amendment, then court will say whatever your urgent need may be there, but caveat is there, I have to issue a notice. And issue notice will deprive your entire cause. Similarly, you see manual, civil manual, in para number 26 and 27, these directions are given to the court by the Bombay High Court itself, saying that in spite of a caveat, if there is a real urgent matter, you should go for passing an ad interim injunction. That is para number 26 and 27 of the civil manual also. So this High Court amendment is so important. You can see Order 8, Rule 11. Suppose some injunction is there. I'm talking about Order 39, Rule 11. Some injunction is there and a breach of injunction is done by the party. What is the remedy? Mostly we'll go for a contempt. That injunction was there and breach of injunction is there. The contempt will have to be filed as a separate proceeding. It will go on with his own speed. Probably if a contempt is proved, the person will be whatever punished according to law. Question is not that you are there for a punishment. You are there either for taking a decree or dismissal of the suit. For that, how you can exploit the situation? For that purpose, if you see Order 39, from Rule 1 to Rule 10, it's Central Act. But Rule 11 is a Bombay High Court amendment to the Order 39. And there, Order 11 says that if breach of injunction is done, then if he is a plaintiff, his suit will be terminated. If he is defendant, his defense will be struck out. You want that, friends. If you are a plaintiff and defendant is causing a breach of injunction, his defense, struck down his defense, is best for you. You will get a decree. And if you are a defendant, plaintiff want a decree, his suit will be rejected if the injunction is breached by him. This is in a Bombay High Court, friends. There are many such amendments. I should take, I had a list of that amendment, but unfortunately, we can't discuss all these amendments. See the important amendments, particularly in the period of 1960s, 76, all these amendments are designed, very useful amendments are there. They are designed with the power which are there under section 121 to 131 of the Civil Procedure Code. This particular aspect, that the amendment whichever are there should not be inconsistent, is also there in section 129 of the Civil Procedure Code. Last one example, when you are making an execution of a decree, you know Order 21, there is a procedure under Rule 97 to 100, which we call as the intervention by the third party. If particular decree is there and a decree holder wants to execute, but however, the third party is in possession, who is not defendant to the suit, that third party can come to the court as an intervention and say that I'm in possession. Hear me. That is called as an application under Order 21, Rule 97. So 97, 98, 99, 100, 101, and 102, etc. is the inquiry, the nature of procedure given. Here, Rule 102 is there, which says that if the intervener has created his interest during the pendency of litigation, that is a lease pendants, then he will not be entitled to file an application under order 21, 97 to 100. So if it is a transaction of a lease pendants, that lease pendants transaction will not be entertained by this particular court on the basis of rule 102, lease pendency affected interveners. Now in 102, you just open the civil procedure code, and on the last line of the 102, you'll find that there is one endorsement. Deleted for Bombay High Court amendment. Rule 102 stands deleted for a Bombay High Court. We will read the CPC as it is. If you take a Central Act, and 102 is there. I had this occasion when I relied on 102, and one of the junior stands and said that, sir, though you had 3-4 books on the Civil Procedure Code, you forgot to see the High Court amendment to Rule 102. 102 Bombay High Court amendment says that it is deleted for the state of Maharashtra. It's not available for us. So I was surprised to see that really a small line was there below the 102 rule, where it was said that this rule 102 is not applicable to the proceedings which are affected by the lease pendants. So this is an importance, friends, of the Bombay High Court amendments. So Civil Procedure Code, sections, orders, appendix, plus Bombay High Court. 4 things are there. You must prepare your own chart. You must see the logical sequence behind all these things. Then connect yourself to the civil manual. Do this exercise. You have a time now. Corona vacation is going on. In this time, these types of exercise gives us some very sound relief to your mind also. And make this comparison. I was supposed to share some of the charts which are there. I will share it to the Shraddha madam definitely. If you find it useful, try to prepare your own plan. Don't follow my charts. I've prepared how sections are connected to orders, how orders are connected to the manuals. That chart I have prepared in my own book. But the question is that don't follow anybody's chart. If you want to learn it by heart and use it, spend 2 days for that. Simple, 4 hours a day. Make a comparison. See how they are connected to each other. And you will find that this particular exercise will be useful for you for entire practice purpose. So take some good time, have some good exercise, keep your mind fresh, do some legal work, legal research, read something like Keshavananda Bharati, EDM Jabalpur, try to read that. Also try to read the book written by Honorable Jia Modi, 10 Judgments which has changed the civil society, Indian civil society. Read something like that. Exchange your views, and also apart from the boring subjects of the law, keep something live discussions which are relating to the various developments of the law and various good happenings. What has happened in the Keshavananda Bharati and the entire trial, how it was an argument, and how the exchange between the judge and the advocate was there is also a good story. If you get some opportunity, we'll discuss that good stories also at some time. Of course, it's a great profession. Coronavirus or any virus can't make us helpless. We are there for a justice, friends, and we are sure that we'll come out of this situation and we'll again fight for the justice of the people. Thank you very much.